Hello, this week we are already on Chapter 8, which is Consent to Treatment. Okay, so the law recognizes the right to control one's own body, including medical decision making. And there are federal, state, case law, and common rule laws that coincide with consent to treatment. Okay, so rights regarding consent can be affected by age. So, like minors aren't allowed to consent to their own treatment. They'd have to have a legal parent or guardian consent for them. Competence. So, typically, this would be like if someone doesn't have the mental competence to make decisions for their health. And emergency circumstances. Okay, treatment without consent or without proper consent can result in liability for negligence or battery. Okay, so what is consent? So consent is a broad process that can be in written or non-written form and vary in terms of how much information is provided. In most cases, consent involves a patient's acknowledgement that he or she understands a proposed intervention, including that intervention's risks, benefits, and alternatives. So there are 3 different types of consent. We have express consent, implied consent, and informed consent. And we'll go through each one now. So express consent is consent that is communicated through written or spoken word. Written is more desirable because then you have either a written or electronic form that the patient signs saying they were informed of all of the risks and benefits and all their questions were answered and they choose to have this medical procedure or intervention done. With verbal consent, that can't be proven and typically is looked at as like hearsay. So this doesn't necessarily mean informed consent. Okay, implied consent. This is a consent for treatment communicated through the person's conduct or other means besides words. So this is most appropriate for non-invasive, low-risk interventions, such as patient presents self for appointment and submits to an exam. Law presumes consent is given by the patient needing emergency treatment. So if they come into an emergency room and they are unconscious, that would be considered implied consent because it's an emergency procedure, and obviously we would think this patient would want them to take any measure necessary to help their survival. Okay, informed consent. This is part of a standard for care required by CMS and the Joint Commission. This means that a patient's consent should be informed. It demonstrates a competent patient's understanding of the treatment and voluntary consent for it. This should not just be a form that's signed, it should actually be a discussion between the patient and the provider, and it's the responsibility of the treating provider. So it includes information material to the patient's decision. It shows that procedure consented to equals the procedure performed, and informed consent should be documented in the health record and a form should be placed in the record. Okay, so informed consent, the question comes up to what shall be disclosed to the patient. So they should be telling them the diagnosis and the nature of the illness or injury, the purpose and nature of the proposed treatment, risks and benefits and probable success, alternatives, whether they're invasive and non-invasive, risks and benefits of alternatives, risks and benefits of not receiving or undergoing a treatment, names of individuals who will provide the treatment, and other information that would be material to the patient's decision-making process. Okay, informed consent and HIPAA. So HIPAA addresses informed consent through its authorization requirements. There should be a separate informed consent for research. However, HIPAA allows an organization's institutional review board, IRB, or privacy board to permit compound authorizations. So they can combine informed consent for treatment with authorization for use and disclosure of a research subject's health information. Some exceptions to informed consent. Sometimes it's impossible to get consent prior to performing an intervention, especially if it's like emergent. The law provides exceptions to the informed consent requirement as well. So like I said, in emergency situations, either the patient can be like alert and cognizant, but time does not permit full disclosure of risk related to intervention, because maybe the patient is internally bleeding and they need to get that taken care of right away. The patient may be incapacitated. In that case, they are unable to be spoken to and understand and provide the consent. These type of emergencies must be documented in the patient's record to prevent liability. So they should document, the provider should document the emphasis on the threat, immediacy, and magnitude. And Good Samaritan statutes protect against liability for failing to obtain informed consent prior to rendering emergency care. Okay, so there is government action that can be taken if treatment is required or authorized by law in criminal or civil cases. So in criminal cases, this often pertains to requests by law enforcement. For example, if they need the patient to give a blood sample to test for alcohol to see if that had to play in maybe an accident, or any mandatory interventions for certain infectious diseases. In civil cases, mental or physical condition of a party is at issue and the court can order an exam. And cases involving mental competence, emergency admissions of mental health patients, and court-ordered examination of criminal defendants. Some exceptions to informed consent. There is a waiver, but it must be patient-initiated. Maybe the patient's like, I don't want to know the risks and benefits. I don't want to be informed, just do it. Obviously, this is not recommended, because what if that patient comes back and says, whatever. That's why there needs to be a waiver filled out and signed. Or a waiver may be approved by the Institutional Review Board for research subjects. Okay, therapeutic privilege. This is a disclosure that may be of significant detriment to the patient because the risk of disclosure outweighs the right to be fully informed. It does not apply if the only fear is that information would cause the patient to forego treatment, and it's highly discouraged. Risk is too common to warrant special disclosure, or risk is remote and improbable, not material to the decision. That may or may not be a valid defense in a legal case. Okay, this chapter also goes over advance directives, which are legal documents that specify an individual's healthcare wishes in event of temporary or permanent loss of competence. These advance directives may appoint another person to make decisions for oneself if they are unable to make them for themselves, may leave instructions on restricting use of equipment or procedures to prolong life. All right, powers of attorney, POA. This is a legal instrument used by a person to grant legal authority to one or more agents to make certain legal and financial decisions on behalf of the principal or the person. In order to have a power of attorney, the patient or person must be mentally competent. The power is granted to the agent and must be defined in the POA instrument. So there are a couple different types of POAs. You have the durable POA and durable POA for healthcare decisions. POA must be durable, otherwise only good if person is competent or has capacity. If a person becomes incapacitated, the POA would be void. State law defines language to create a durable power of attorney versus a power of attorney. And a durable power of attorney may act for a person in legal, financial, and real estate matters. Okay, then we have the durable power of attorney, DPOA, for healthcare decisions, HCD. This can be called a medical power of attorney or a healthcare proxy, and it may be revoked at any time by the person who instated it or the patient. This authorizes an individual to make personal healthcare decisions if the authorizing individual becomes incapacitated. Unlike the power of attorney, it is in effect when the principal is incapacitated. That's why it's durable. Principal must be competent when executing this durable power of attorney. The agent must make decisions consistent with the principal's wishes or in their best interest. So like I said, it may be revoked or have an expiration, and a copy should be kept in an easy to find location as well as in the health record. Living will. Competent adult prepares documents providing direction as to medical care in case of incapacitation or inability to make personal decisions. This can also be called a healthcare directive or advanced care plan. State requirements can vary, but typically always include at least a signature date and witness. Limitations on care that the patient may want generally involves, like, maybe they don't want use of respirators or any artificial supplied nutrition and hydration through an IV. And maybe they would like to say if they need CPR, they don't want it. So this is typically very common in like senior citizens. So maybe if they're, at a certain age, they don't want any life-saving interventions. This also may be revoked, and a copy should be kept somewhere that can be found as well as in the health record. DNR, do not resuscitate order. This is a no CPR, no code blue order. So that means that if there's any type of emergency involving that patient, they would ask that no life-saving intervention be done. So do not resuscitate. It can be revoked if the patient has a change of heart and does want to be resuscitated in an emergency. The Joint Commission requires all accredited acute care facilities to have policies and procedures in place regarding these advanced directives. Okay, Patient Self-Determined Act, PSDA, federal statute, effective in 1991, raised awareness of advanced directives. It applies to providers receiving Medicare or Medicaid funds. So the provider must inform patients of legal right to make medical decision and the right to create advanced directives. They must document in the health record, educate staff and community, not condition care or on presence or absence of advanced directives, and ensure compliance with state laws. Uniform Anatomical Gift Act, this is for organ donation. So it outlines the making of an anatomical gift by a patient in the case they perish. So who can consent to treatment? Typically competent adults. Age of majority varies by state. They may refuse to consent or authorize withdrawal of treatment, which has to be recorded in the record based on religious beliefs pursuant to advanced directives or providers being cautious in treating a non-consenting adult. The medical record is the primary and sole source of documenting decision to withdraw or forego life-sustaining medical treatment. Uniform Healthcare Decisions Act, model law that provides another option to creating a durable power of attorney for healthcare decisions. So it provides for a decision-making surrogate. Incompetent adults are generally categorized as adults who were once competent, adults who were once competent but did not execute an advanced directive, or adults who never had competence. Minors, legally classified as incompetent unless they are an emancipated minor or identified as mature. So they do not have the legal right to consent or refuse treatment. The parent or guardian would be the one that would have to give consent. And there are state laws that need to be followed. Challenges to consents: if the patient did not give consent, that can be battery. If the patient was not fully informed of risks or other factors that would have been material to the patient's decision, that can be looked at as negligence. The patient was not competent at time of completion, the form was too technical to be understood, or the signature was not voluntary. Documenting consent must always be documented in the record as required by the organization, CMS, and the Joint Commission. There are many different consent forms. You have the general blanket consent form and a short consent form. Or there's a long consent form, which includes a lot more information. All right, that is Chapter 8.